do so. The committee may ask for a brief presentation of the application, followed by questions from members and submissions from the public. Please address your comments to the chair, stating your name and spelling it if necessary, and your municipal address for the record. The committee limits presentations to 5 minutes. Any exceptions will be at the discretion of the chair. And we do have a long committee agenda today, so we will be trying to stay on point there. So, are we ready to proceed with the agenda? First, we will ask, are there any declarations of interest from any of the panel members? Seeing none, we have no minutes. Adjournment requests. The committee has received several requests to adjourn, and we will deal with them. So on the agenda, we have 3 requests, and we'll be dealing with them in the order that they appear on the agenda. And then we have an additional item that we will be speaking to after we deal with the adjournments. So we will deal with item 5, University of Ottawa. Is Miss Gibson available? Does the coordinator know if Ms. Gibson is present?
Yes, she is. I see her online now.
Sorry, I was muted.
Hi there.
I'm here. Hello.
So there has been a request by the planning department for a recirculation.
Yes, that's correct.
And you're aware of that?
Yes.
Do you have any concerns with that?
No, I do not.
Okay. Does any member of the committee have any questions regarding the enclosure or the encroachment at all at this point, or Member McLean?
Just wonder if the applicant or the agent could clarify the size of the garbage enclosure. I just noted maybe a discrepancy in our notice and the letter, the cover letter.
Certainly. Sorry, I wasn't prepared. I thought I was 5th in line. I'll just grab the dimensions for you.
If that's not doable, just maybe confirm them with staff before the next notice goes out with the new variants. Or
yeah, absolutely. So it's 6.44 meters long. And the width is 3.076 meters.
Okay, thanks very much.
You're welcome.
And Member Wilder?
Yes, are you aware of some of the concerns that have been raised with regards to this application, with regards to the garbage management, encroachments, lack of landscaping, etc., things which I don't want to raise today, but I probably will raise at the next meeting when it comes back. So as well, there's been some comments that have come in from Councillor Fleury, so you might want to be aware of that as well. Thank you.
Yes, thank you.
Seeing that there are no further questions or comments on adjournment, members of the committee, is this adjourned? So you're adjourned, sine die, and we'll see you back when the time is right. Thank you.
Great. Thank you very much.
Okay, we will now move to item 14 on the agenda. And if the agent is available.
Good afternoon, Mr. Chair.
Hi there. Please state your name, please, for the record and your address.
Absolutely. It's Corey DeBow, and my address is 421 Churchill Avenue North.
Thank you. So you're aware of the request by the planning department for a recirculation and to adjourn on the basis of a sine die?
Yes, Mr. Chair. There was a small discrepancy in the zoning code changes due to the sort of the Westboro development overlay. Just as we applied within a 2-week period, it was a rather inconvenient time-wise, but I guess we'd like to request possibly a meeting as soon as possible, just to adjust these changes if possible.
So for the Deputy Secretary Treasurer, what is the timeline for a recirculation?
Mr. Chair, if the application is to be recirculated, excuse me, we will need a new check covering the recirculation fee, at which point we will schedule the renewed notice for the soonest possible hearing. I believe at this point, it's likely we could receive a check this week or early next week. It will be the first hearing in August.
Which is what?
August 4th?
August 4th, Mr. Chair.
So you may wish to go sine die anyways, just in case something happens. And I mean, if you can get your information in on time, you've heard that, you know, if it's provided on time, you could probably meet the August 4th meeting date. But I would recommend you stay with sine die just to be safe.
Okay. Okay. Thank you, Mr. Chair.
See with what? Oh, okay.
Any questions or comments from committee on the adjournment?
Got any questions?
We'll see
No,
you
at this point, I guess just not really, we just got to go with the flow, I guess.
We'll see you again soon.
Okay, thank you.
Okay, we're now moving to item 18. 7 Rosedale. And we've had some requests for adjournment. Does anybody wish to speak to that? Is the agent present for 7 Rosedale? The committee coordinator, is the agent present?
Yes,
We
Mr.
have
Chair.
Mr. Vanessa online.
Hi there. Richard Schmiel is the agent. I'm the owner. Can you hear me?
I can. Can you give us your address, please?
Sorry about that. Robert Vanessa, 7 Rosedale Avenue, Ottawa, Ontario.
Thank you. You're aware of the request for adjournment?
I'm aware of it. Richard Schmiel is the architect acting as my agent. And I just see that he's trying to get the login and the password to get in on this meeting right now.
Okay. Do you have anything you wish to note for the committee, or would you rather wait for your agent?
I'd rather wait for my agent, please.
Okay. Give them a minute to get in. And we do have a couple of other people who wish to speak as well. So we'll get to them as soon as your agent gets in.
Okay.
We'll give them another minute or so. We may stand this down momentarily to, we want to give him the opportunity to hear what the other speakers have to say. We'll give him another 30 seconds or so.
Sure. By all means, proceed as you see fit.
The committee coordinator, is the agent showing up?
No, Mr. Chair, he's not online yet.
Okay, we're going to stand this down while we speak to the next item, and we'll come back to it. So the final item under other business is a change of condition request for 304 Lanark. We will be dealing with that for those who are in attendance today at the end of today's meeting. So stay tuned for that. It may be a while. It's a bit of a long agenda today. So we will move to item 1. Is the owner or agent present?
Hello, am I online?
You are. Your name, please, for the record.
My name is Renzo Cicchetto. I'm the agent for 16 Glendale, and my address is 1454 Tedder Avenue.
Thank you, sir. We do require a sworn oath, so I'll read it to you. You solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time.
I do.
Thank you, sir.
We may have the owners online as well. I'm not certain.
Okay.
Yes, this is Jason Anderson. Sorry, I am online as well.
Thank you, Mr. Anderson. Committee has thoroughly reviewed your application, and we don't believe that we require a full presentation. We are looking at this particular one from the perspective of likely tying it to plans. Do you have any concerns with that?
No.
Okay. Does any member of committee wish to make any inquiries? Are there any individuals who wish to speak to this? Hearing none, is committee prepared to make a decision on this application? Okay, all in favor? The item is carried. Good luck with your project.
Okay, thank you very much, committee members.
Committee coordinator, is the owner for item 18 available now? The owner and agent?
No, Mr. Chair. Oh, actually, as I speak, I do see Mr. Chamil is logging on. So I believe we have everybody now.
Okay, we will go back to that. So we have the agent and the owner available. I see Mr. Vanass. Is Mr. Chamil available?
Yep, I'm on here. Let me go to video. There we go.
Thank you,
Hi
sir.
there.
There is a request for adjournment for your file. Do you have anything you wish to bring to the attention of the committee?
I don't, Robert, what do you think? You're okay for an adjournment?
It's up to you. I mean, we have been waiting for a while. If you're prepared to present everything we need to present, which I think we are, we should try and proceed.
Well, we're asking you on the matter of adjournment. What is your comments on the matter of adjournment? There have been requests for adjournment. Do you have any comments on that?
I mean, what kind of adjournment is it? Like to the next hearing or like for 6 months, or what are they thinking?
Well, I believe that there's a request to have some further discussion on a few matters. And in all likelihood, we're probably looking at August 4th, I believe.
I think, Robert, I think we could do that. Maybe that allow us to maybe have some discussions with those people that have written in.
Sure, I follow your recommendation.
Yeah, well, I mean, we're happy to move to August 4th if that works for everybody.
Okay. And we do have a question from Ms. McLean.
I just wondered, I wasn't able to view an up-to-date survey plan showing the location of the building and the easement. Is there such a plan available?
I think there is. We submitted a site plan that shows the easement in our submission.
No, I'm looking for one that shows the location of the new building or the building that was constructed relatively recently, I guess. And in location or in conjunction with that easement and the lot line.
I think there is. I mean, if you want me, I could share my screen. I could just show you.
No, that's fine. I'll just check with staff, and I didn't see it, but that's fine. If there's one on file, I'll have staff send it. Thank you.
Okay, sure.
Member Wilder.
Thank you. The request for the adjournment was made by one, I think, or one or possibly two abutting property owners. I just like to, well, I guess I'd like to know why it's needed. This has already been, deferred once. I thought by now this whole matter would have been resolved with regards to the easement. It was adjourned back October of 2020. Now it's back before us again. Mr. Chair, should we just hear from one of the neighbors of why they're requesting this? What has there been no discussion between back last October and now June?
Yes, and Ms. Marsman is waiting to speak, so we will ask Ms. Marsman, please, if you could articulate your position on the adjournment.
Yes. Hi, Kathleen Marsman. I live at 17 Rosedale. And the reason for the original sine die adjournment was because there was no legal opinion to interpret the rights in the easement. So our position as neighbors that share rights in the easement is that the rights extend from ground to sky. And we have, reason to believe that that's the case. It's in the deeds of our properties. So the variance that's been requested is to jut into the easement in a way that we object to. And when it was adjourned sine die, we understood that there would be an opinion rendered, maybe by the city, to determine the City of Ottawa's interpretation of easement rights, and whether or not an independent view of easement rights would confirm that they are ground to sky. So the new plan was not available to us, and we see that there is also a memo written by some lawyers, of course, advocating for the position that the easement need not be respected ground to sky. This wasn't a City of Ottawa opinion, and it's actually not a legal opinion, it's a memo. And it's a memo summarizing perhaps 4 cases that favor the applicant's position. So we just received that memo around the 23rd of, well, we didn't even receive it. We received this notice on the 23rd of June and had to, of course, dig into the file, and then we found the memo. So there's been no discussion with the neighbors with this. And of course, the City of Ottawa hasn't obtained that legal advice either. We had hoped that the City of Ottawa would be obtaining a legal opinion. As an independent party on this matter, that would be our preference. And we'd like to adjourn until the City of Ottawa does obtain that memo. And if the City of Ottawa won't be obtaining that memo, we need to know, because then the neighbors will, of course, have to band together and spend the, not hundreds, but thousands of dollars to get a legal opinion. We didn't obtain that legal opinion in advance because it seemed pretty clear that major changes would be needed for this application to proceed. And we had very much hoped that the applicant would reconsider building a staircase that juts into the laneway, into the easement that we have rights in. So we were disappointed to see that the plan was very similar and still abuts onto the laneway. So that's why we're asking for the adjournment, so we can determine whether the city is going to get an opinion, whether we need to fundraise and get our own opinion. And we would also very much like to talk with Robert to see if there are any other options for a staircase that doesn't overhang the laneway.
Thank you. Could I have the planner, Ms. Wakala?
Yes, Mr. Wong.
That was interesting. You were definitely didn't sound normal. Yeah, your audio, there's something severely wrong with it.
Like that, it's better?
Yeah, much better. You
Yeah,
sounded
okay.
slow motion there. It was quite entertaining.
Okay.
Your comments indicate that there are minor concerns, and however, the minor concerns are not a matter of the planning staff has authority on. They are of a legal perspective. Did you speak with city legal staff? Did staff speak with them to get any opinion on where the line is drawn between whether it's the city who comments on this or not?
So in fact, we actually circulated, the planning team circulated the memo that was sent by the applicant with legal services, and the Timothy Mark legal representatives in the city agreed with the memo that the addition as proposed is not interfering with the legal right to use the passage for vehicular and pedestrian access.
I see. Okay. So the position is that it's not a matter that this committee should be concerned with as they make their decision. That's
It's
coming
not
from
a planning concern, yes.
There is another condition comment from Hydro Ottawa that say that revisions to the plans may be required. We have consistently not approved applications when there is a condition like that or a comment out there. We look to the agent to go back to Hydro to see how serious the concern is before we render a decision. Ms. Wakala, if you could just stand by, but for the agent, have you had any discussions with Hydro?
No, I haven't.
And how about the agent?
If I could speak to that, the information from Hydro came fairly late, so we didn't have a chance to go back to Hydro. Because the way the Hydro is situated now on the property doesn't meet their intent as it is, so I'm not sure what our changes would affect Hydro's requirements for access. So we'd have to have another conversation with Hydro.
All right. Well,
but as one more comment, if it turned out that Hydro, was clearly and saying we couldn't do what we wanted to do because we affected Hydro, obviously we wouldn't go ahead.
Right. So consistently, what we do is we do send you back to have that discussion with Hydro to make sure that something can be done to resolve the issue with Hydro before we render our decision. In light of that condition and in light of some of the comments from the neighbors and your indication that you'd be willing to speak with them, I am going to suggest that we adjourn to August 4th. Does any other committee member wish to speak to that? Okay, based on that, I strongly urge you to speak with Hydro in the ensuing weeks, so that when you're back on August 4th, that you have some information for us about that, as well as some information about your dialogue with the concerned residents. On adjournment to August 4th. Okay, we'll see you on August 4th. Thank you very much.
Thank you.
Thank you.
Thank you.
Okay, next item is items 2 and 3. None for others. And do we have an owner or agent present?
Good afternoon.
Hi there. Your name for the record?
My name is Suryan Shahzadeh.
And your address, please?
Suite 200, 240 Michael Copeland Drive.
Okay, thank you. We've been through your application thoroughly. We don't feel we need a full presentation, although we do have some
Mr. Chair,
questions.
can we get a stat deck, please?
Oh, yeah, sorry. I'm doing like the regular chair. Sorry about that. Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time?
Yes, I swear.
Thank you. I'll try not to do that again. As I was saying, we've been through the application. We do have a few questions, some for you, perhaps some for confirmation from the planning department. With respect to the one lot for bylaw, we're a little unsure about how the minor variances have been listed, and if we could perhaps ask the planning department why it appears in the way it has, because normally what we see is that the variances would be on a one lot for bylaw purpose.
Yes, Mr. Chair. It's a good question. So this lot for long semi-detached has to be treated like a one lot from the zoning perspective, and that's why the variances are listed like that.
Well, if it's one lot for zoning purposes, would you not only have the it apply to all parts rather than two separate? You've got an A and B, and then you've got an E and F.
Perhaps you're right, Mr. Chair. Yes.
Ms. McLean, do you have any comments on that?
No, those are my questions too. If it's one lot for bylaw purposes, there should be one set of variances pertaining to the entire lot. I also had some questions for planning related to conditions for the, there seem to be some steps extending into part 2. The structure in front of the proposed parking space. And I had a question for the agent on the maintenance of the eaves related to the southerly wall of the existing building. But I think we need to, straighten out those minor variances on the basis of the one lot.
For the deputy treasurer, secretary treasurer, how do you recommend we look at these?
Mr. Chair, we would follow any direction we receive from the committee or alternatively from the applicant as to how they would be comfortable proceeding with requests for relief. Ultimately, we would leave it to them to dictate the form of their application to the panel.
Okay, for the agent, do you understand where we're heading with this, and do you have a recommended course of action?
Sorry, my internet cut out. I missed your question.
So we've been discussing the fact that we believe this is one lot for bylaw purposes, yet the minor variances don't really reflect that. Do you have a recommendation on how you would like to see these amended to do that?
Murray, do you have any comment on that?
So, Mr. Chair, I'm just looking through the list of variances that have been requested. So to your point, variance A and E could be combined. So they apply to both, to the entire parcel. Same with B and F. Just going through them. I would say the same for C and G, they could be combined. Yes, I appreciate the question, and I think it's a valid question. I think it would be appropriate that we maybe amend the application so that we're just dealing with A, B, C, and D. They apply to parts 1 through 5, and then remove variances E, F, G, and H. I appreciate the question.
Members of the committee, are you comfortable with that suggested amendment? Seeing none, we'll move on to a few of the questions that Ms. McLean had with respect to the steps, the eaves, and I believe the pole as well, Ms. McLean.
Yes, just one more clarification. There was a variance E to permit a flag lot configuration with a minimum lot width of the pole portion of 2.5. That was outlined in your letter, but I don't see it on the notice. So I'm wondering if it's still required.
It is not still required. The bylaw has since been amended to allow a flag lot portion of 2.2 meters. So we are in conformity with the bylaw.
Okay, thank you. And could you tell me if this is a remnant parcel to a previous severance?
Yes, it was to the abutting 86 acre others.
Okay, and so I'm just wondering if you could address the how the maintenance of the southerly eaves on the existing wall, they seem to encroach on the flag portion of the lot to be created. And then as well, there's steps encroaching into that part too, and there's a vinyl shed. Just wondering if they need to be conditions or how they're being dealt with.
The stairs are going to be relocated from part 2 over onto part 1. So that's fully on the parcel of the existing dwelling. Do you have any comment with regard to the eaves?
Sorry, is the question about these with respect to the existing house to the north?
The eaves on the existing house, will they be encroaching on the flag portion for the semi at the back?
At the front, okay.
Yeah, of the existing house.
I'm
just wondering if they're being addressed or if they are encroaching.
I think they could be addressed through the joint use and maintenance agreement, Madam or Mr. Chairman. I understand the question.
And then the other question related to the vinyl, is there a vinyl shed in front of that new proposed parking space? Is that going to be removed? I'm just looking at conditions.
Yes, it's proposed to be removed.
Okay, thank you.
Any other members of the committee have questions? Our committee coordinator, does anybody wish to speak to this that you're aware of?
We have no registered speakers, Mr. Chair.
Okay. So the conditions listed are cash in lieu, independent services, grading and drainage plan, and the JUMA, as you said, and I agree with you, Mr. Chown. I think that could be addressed, the matter of the encroachment, if there is one. Ms. McLean, were you suggesting that there would be a 5th condition about the demolition?
I think 2 conditions: that they provide evidence that the stairs have been relocated in conformity with the bylaw, if that's the position, and that the detached shed, I guess, be removed.
Does the proponent have any issues with that?
All those are fine, thank you.
Okay, on these applications as amended, members of the committee? And we are carried. Thank you and good luck.
Thank you.
Thank you very much.
Okay, now moving to item number 4, 1040 Somerset Street. Is the agent available?
Hello, Mr. Coordinator.
Hello there, Mr. DeYoung. Okay. Your name officially and your address, please.
Thanks, committee. My name is Vincent Deneme. The address is 210 Gladstone Avenue, Ottawa, Ontario.
Thank you. And I do see that we need to have a oath for the sign, so I'll read it to you. You solemnly swear or affirm that the notice provided by the committee was posted on the property to which the application applies for the prescribed number of days before the hearing as instructed and is clearly visible and legible at all times.
I do.
Thank you. So, Mr. Dunham, we've been through this fairly carefully as a committee, both individually and as a group, and we have a pretty good handle on this. We do have a couple of questions. One being, I guess, sort of a broader question: why can't the parking be provided? And second, why not, if there needs to be a reduction, why not owner parking versus visitors? So if you could respond to both of those, please.
We have a very, very tight site with a small footprint. And with the drive aisles, it's very difficult to get an efficient layout. So every spot counts here. And to go, the amount of levels that we want to, we would like a reduction in both. Seeing as there's no minimum requirement for resident parking, we didn't need a variance. But with the visitor parking, we did. So we did do a reduction in both. It's just we didn't need a variance for the resident parking, seeing as the requirement is 0. I hope that answers both your questions.
Yes, thank you. There are no conditions. Does any member of committee wish to ask any questions or comments? Ms. Oak-Charon, please.
Thank you. There have been some concerns raised by residents in the area that this will have an impact on parking on nearby to the site if you don't offer the required number of parking spaces. So I was wondering if you might be able to offer some comments to speak to that.
I mean, there's already quite a bit of street parking that's being used up on the site. I don't think that'll go away with our site being built, but we're really hoping that people use the LRT, seeing as it's less than 400 meters away from a station to get to our building. So there's always concerns with parking, but we feel that we're only asking for 6 spaces less. So kind of hoping that people use the LRT to get to the site instead of their car.
Thank you. Are there any speakers who wish to speak to this?
No, Mr. Chair, no registered speak.
Thank you. On this application, members of the committee, is this matter approved? It's carried. Thank you and good luck.
Thank you.
Item 5 has been adjourned. Moving to item 6, 475 Cambridge Street South. If we could have the owner or agent, please.
Hello, sorry about that. Hi, Mr. Chair.
Hi there.
The agent on
state your name, please, and your address for the record.
Agent Psyche, and the mailing address on file is 475 Cambridge Street South.
Thank you. And I see we do have a statutory declaration received, so thank you. We had a question actually for planning staff about this one. So if we could have the Mr. Hamilton for a moment, please.
Yes, Mr. Chair.
So the question is, do we require a change of use only, or do we require also an enlargement?
I believe the understanding is that it would just be the enlargement to add the additional unit atop.
Any member of committee wish to explore that further? Ms. McLean?
I just wondered if, because the cover letter expanded on a change of use. But the notice is talking just about the enlargement of the building. I wonder if the applicant could explain what the residential use is going to be.
The residential use is going to be a primary residence for myself and for my wife.
So the previous application dealt with rooming units. That's not the case in this?
That's no longer the case.
Okay, thank you.
Thank you.
Are there any other questions from members of committee? Okay. On this file, is this matter approved, members of committee? Thank you. Your application is approved. Congratulations.
Thank you very much, Mr. Chair and committee members. Thank you.
Thank you.
Thank you. All right, we will move on to item 7, 302 West Hill Avenue. And I believe we may have a question for planning staff or Ms. Young on this particular file. We've reviewed this one pretty carefully as well, and we don't feel we need a full presentation. Is the agent or owner available?
Yes, Mr. Chair, I'm here. Brian Ernst.
And your address, sir?
656 Edison Avenue, Ottawa, Ontario.
Thank you very much. I'm not sure, is Ms. Young available?
Mr. Chair, can we get a stat deck?
Oh, yep.
Yes, please.
Sorry. Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time?
Yes, I swear.
Thank you. Back to Ms. Young. Is she available? And if not, Ms. Young, the planner.
Yes, I'm here.
So Ms. Young, I guess the question the committee was trying to wrap our minds around was this tree planting plan, not so much the plan itself, but how it gets operationalized in terms of how does it get done, and with the change in ownership, how you impose that. And from what we understand, that panel 2 of the Committee of Adjustment has also been wrestling with this a little bit, and there has been some proposed wording to help make that sort of more operational through, as we understand it, a form of agreement. Are you aware of that?
Yes, I'm aware of discussions of how to operationalize this, and kind of the standard wording we've come up with is what I proposed for this plan. So in terms of being operational, it's basically just putting the onus on the developer to say they have to have a plan in place. And I mean, it doesn't really matter who plants the tree. We just need to see a plan in advance of where the trees are going to go. They have already paid deposits in this case. So they're already sort of bound in some ways to plant trees. And this condition is just to kind of ensure that happens, and then they can get a refund of the payment that they've already made.
So you mean that the city has funds in place? Is that what you mean?
The application, because of when it came in, prior to the bylaw change, they paid a fee of $700 per lot for tree planting to be done in the future. So following construction. And so the request for this plan is just to show where that's going to happen. And that's really it.
So I guess for us, the only issue there is that's great that there's a security there, and I think that gives us some comfort. Is how does the I guess the future owner become aware that this is a requirement if the tree isn't in yet and the property changes hands? Were you involved in
that?
drafting?
I'm not sure. I mean, really. Yeah. Sorry. Go ahead.
were you involved in drafting any language for a development agreement, sort of the flag for everybody that this has to happen?
Yes, and so in this case, I haven't asked for a development agreement just because they have already paid the fees, and this is just kind of a softer approach. But for the other sites where they have not paid fees, then we are asking for a development agreement. So yes, that has a better way of kind of moving forward through the future, but this is just more to communicate to people that they need to have a plan in place, and if they need to transfer that plan to the new owners, then that's fine. But the onus is kind of on them.
Okay, thank you. Ms. McLean?
So I just want to understand the process a little bit better. So the applicant is applying to sever the property. One of the conditions that he has to meet prior to the severance is to submit a tree planting plan, period. Once he does that, he's fulfilled the condition. He goes along and he severs the property, sells it to the new purchaser. So what happens? How do the trees get planted? I just want to understand the process.
And yeah, this is the soft approach, and there is some risk that it won't be done. But that means that they will not receive a refund of the funds they've already paid. So that has already been done through the issuance of the building permit. They've paid these fees. And so this condition is just kind of a reminder that this has to happen. And if it doesn't happen, then the city will retain those funds and we can come in then and plant trees, but they will not receive that money back.
So do we need a condition, I guess the question is, or you're saying the condition is sort of a reminder notification on the issue, and if he decides to forfeit the 1,500 or the 700 per lot, that's the city will use the money for that, I guess. Okay. All right. Thank you.
So I think in this case, the softer approach may be reasonable given that there's a security in place, whereas in the future, there may be a different approach needed. I think I understand that. Yes, Mr. Wilder? Right.
Yeah, two questions to the planner. What is the status of the site plan agreement at the moment? How far along is it?
Sorry, they're given that it's semi-detached townhouses, it doesn't require a site plan agreement, as far as I understand.
I thought for this, okay, I thought for this application, for the Montreal application, there is a site plan agreement in process, is there not?
I'm sorry, I think that might be the application following this.
Oh, I'm sorry. Sorry.
No problem.
My mistake. Sorry.
Okay, so for the applicant, we have, I mean, I'm comfortable with what Ms. Young said in this particular case. However, in the future ones, there might be a bit more work required. We have cash in lieu. We have party wall to meet 1 hour fire separation, independent services, the JUMA, and the provision of the tree planting plan. You're aware of those?
Yes, Mr. Chair.
No concerns?
No, sir.
Okay. On this, is this matter approved, members of the committee? Thank you and good luck.
Thank you.
Okay, moving to items 8 and 9, 458 Montreal Road. We have the agents, please. Ms. McQuaig, I believe.
Good afternoon, Mr. Chair.
Ms. McQuaig, just for the record, your name and address, please.
Christine McQuaig of Q9 Planning and Design. Address is 24 Kirkstall Avenue.
Thank you. And will you be doing the oath?
Yes, I will be doing the oath.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time?
I do affirm.
Thank you. So This is a fairly complex file. However, the committee members have been through quite a bit of this as well. And we wanted you, I think, to walk us through the 4 variances and sort of explain each and every one of those to us, but you don't have to give us a full presentation at this point. Then we've got a series of other questions that we will be asking.
Mr. Chair, if the coordinator can share our presentation and flip to slide 9, I think that just in terms of time saving and getting into the variances, that would be appropriate and appreciated. Thank you. Perfect. So on the screen before you, Mr. Chair, members of committee, is the current site plan that is before staff in terms of the second submission that we've provided for our site plan control application. The variances that we're seeking, and I'll provide the rationale sort of as I go through them. Variance A is addressing the maximum front yard setback from Montreal Road. The current maximum in the bylaw is 2 meters. It does also allow situations of 5 meters where there's hydro conflicts with existing poles. And for some background information, while hydro is being buried on some parts of Montreal Road, on the south side, it is not being buried on other parts of the south side of Montreal Road. So there will be conditions and situations where there will be a 5 meter front yard setback maximum on this location. The setback we're seeking is 8.93 meters, but we are providing a road widening to the city of Ottawa, which will effectively reduce the variances that we're seeking. But we have to seek the variance to the current property line as it stands today. Once the variance is taken, we'll actually end up with a setback from property line that is, I believe, just under 6 meters. So it'll be a little bit more, certainly more in line with the 5 meters that will exist along Montreal Road. And then to the point of the impact and streetscape, if I do have a slide, I believe it's slide 6 that we can jump to for reference. However, I will note that we have taken an assessment of the existing setbacks along Montreal Road along this stretch, and the average, thank you very much, the average setback as we've calculated through Geo Ottawa is an average of about 14 meters. So the majority of the buildings are set back quite significantly. And so our aim really was to propose something that was a little bit more aligned with both the existing context and with the intent of the zoning provision in order to have that maximum front yard setback. Part of the maximum front yard setback that we're seeking also allows us that extra space that's being provided with regards to the corner gateway and future public art that's going to be located on the site. That's a requirement from the secondary plan for this area. So those were the components that were leading into the requested front yard setback. As I noted, the context is there to support that, as well as the existing variation that you'll see for permitted 5 meters just due to conflict with hydro. So in the end result, after road widening, we will be somewhere in the realm of 5 to 6 meters front yard setback, and we consider that to be minor. It does meet that intent, especially because the building is going to be similarly set back to other buildings, both now and in the future, and it provides 100% active frontage. The glass panels are transparent. There's going to be event space as part of that, the space between the street and the front wall of the building. So the active component remains there to address the intent of that provision, as well as the streetscape consistency will also be there. The variance is permitting the proposed use as filed with site plan control. And it's our opinion that it does meet the intent and purpose of the official plan as well, being that the zone for this particular site is in place to permit the proposed use. And it is desirable for this particular use and condition. It sees the removal of the existing Alfa Romeo and Maserati that frankly, it currently encroaches into the sort of public realm feel. And what we're proposing will take the building a little bit, provide some more space towards that public gateway at the corner. If you don't mind flipping back to the site plan, please. It's number 9. Thank you. So that kind of covers off the variance A. And variance, I believe it's B. It's a little bit fuzzy on my screen, but in the bottom right of your screen, you're seeing the existing repair shop at 616 Saint Laurent Boulevard. This is more of a housekeeping item. It's currently there. The existing setback is 0.3 meters. It's not being demolished. We're seeking this variance because this is the area that you're seeing in front of you as being subject to site plan control. And I just want to make sure that that's that's recognized, that existing condition. And then with regards to the landscape buffer, the variance wording that was submitted, when I worded the variance and discussed it with Craig Hamilton, the city planner, I was specifically looking at the area subject to site plan control, and it was a failure on my part to understand that the wording of the variance would have the effect of relating to the southern portion of the Audi site to the left of your screen that's a little bit cut off. And so in discussions with Craig a couple of days ago, I have proposed revised wording so that the variances C and D would only apply along that interior lot line being created between 470 Montreal Road being the proposed Porsche dealership and 458 Montreal Road being the existing Audi dealership. So along that black dotted line is the proposed lot line. And if you can see our current site plan before the city, it does have a 1.8 meter green strip. So that landscaped buffer is still there. It is still being provided. There is still green incorporated into that. But because we're combining the accesses, the parking, and the drive aisles, we're having parking areas abutting parking areas. And so there was a bit of tightness because we wanted to maximize efficiency and reduce overall the amount of asphalt that we would need. And so we end up with a bit of a pinch point towards the south. So where you have parking abutting parking, so there's no impact, which speaks to the minor nature of this variance. But we do require that 0 meter landscape buffer, whereas it would normally apply where a parking area abuts an interior lot line. For example, if this was an AM zone, we would be, we would be able to benefit from that one lot for zoning, but it's a TM zone. So that's where that comes into play, that we need to seek this variance. And given that it's parking abutting parking, the impact is minor. Also considering that we do have that 1.8 meter landscape buffer running along the majority of this interior lot line, we feel that the impact is also minor for that reason as well. And it also speaks to the intent being maintained. So that sort of covers off the proposed amendment with regards to the landscaped buffer. I would like an opportunity to read the wording that is being changed. So if you can jump to slide 12, I'll do that right now. So variances C and D would be modified to read to permit a 0 meter landscaped buffer only along the interior lot line between 458 Montreal Road and 470 Montreal Road, whereas the bylaw requires a 1.5 meter landscape buffer for a parking lot where it abuts an interior property line. And the reason for this is to, buffer parking areas from sensitive uses. In this particular case, the two lots are being developed together. Well, one is currently developed as an auto use and the other one is being developed as an auto use as well. And you have parking lots abutting parking lots. So, we meet the intent by simply developing these and the accesses together jointly. And they do have right-of-ways and easements that speak to that shared access as well. So it's our opinion that the variance we're seeking, all the variances we're seeking are indeed minor based on both the intents and the impacts or lack thereof, and that they serve to facilitate the development of this parcel for the better. And if you want to, I can go into detail with regards to the proposed severances, but as you mentioned, you're quite familiar with most of this property. But just to give you a good visual, if you want to go to slide 17. Thank you. So this is the current, parcel fabric and development that exists on the parcel today. If you flip to the very next slide, it shows you an overview of what the effect of these variances would facilitate. And this just depicts, a greater building front facing Montreal Road, active space at the corner. It has incorporated landscaping along Montreal Road as well as Saint Laurent Boulevard, and a shared access that basically takes two existing road cuts from Montreal Road and merges it into one. So the total effect of all of this is really creating a betterment for this particular area. And we feel that the variances being sought are minor. They do meet the intent and purpose of the zoning and the official plan, just based on the nature of them and the context. And it is definitely desirable for the use of this property. And I'm available to answer any and all questions that you have.
Thank you. You mentioned that there is going to be, for what are we saying, about 2/3 of the property that abuts, there's going to be a 1.8 meter buffer that's going to be there, a landscape buffer, sort of towards the north.
Correct, Mr. Chair. There is on the current site plan before the City of Ottawa today, there is a proposed 1.8 meter landscape buffer that extends for the middle row of parking that does account for probably about 60% of that created interior lot line. It does straddle the property line. So it's not, the variance in the zoning says that you would need 1.5 on either side. So this is 1.8 of a landscape buffer that does straddle that property line. So about 0.9 on each side. And it is parking, abutting parking.
But you're still requesting a zero, a number of 0 in that location.
Mr. Chair, we have to request the 0 meter landscape buffer for the area to the south along that interior property line, where there is parking that's in a tighter position because of where the fire route accesses are and other accesses, and also where the parking areas cross aisles.
Okay. There's a comment about servicing, I think it was storm water, that was driving some of the decision making. Can you explain that to me?
I was not aware of a comment with regards to servicing, but our servicing scheme that has been in review with site plan control does have some stormwater management in terms of how it drains to the site. We did require a blanket easement in order to facilitate, because some drainage may occur from 470 that needs to be dealt with on 458.
I see. Okay.
And this is, if I can just add quickly too, Mr. Chair, part of this is that the site does have some tricky grading. On first glance, it does appear to be a flat site, but it's actually not. There's retaining walls on the site currently. So there was a bit of a very specific design that was proposed with regards to this site.
Thank you. Mr. Wilder.
Thank you. First, I'd like to ask the planner, what is the status of the site plan application?
Through you, Mr. Chair, I do believe that the applicant is on their third submission, and their third submission is currently being reviewed by the development review planner.
All right. Do you have any indication whether or not the councillor intends to lift delegated authority at this point, or it'll be done through delegated authority? Have you any idea?
I personally do not.
All right. Ms. McQuaig, if you have the answer.
To my knowledge, we have no indication that delegated authority was going to be lifted, and to my knowledge, it is being taken care of by staff.
Right. Thank you. Have you seen the comment provided by the Overbrook Community Association?
Yes, we have seen that comment, Mr. Chair, and that is what led to the revision in proposed wording for variances C and D.
I see. And the other question I have, I mean, I realize this is a Porsche dealership, as you point out on page 15 of your rationale, that due to the high-end nature of the vehicles, which, you know, I appreciate they're high-end vehicles, but then does that give you any additional right over other make of vehicles, so that you can have product display in the gateway feature and along the hardscape area with pavers for Porsche events to provide additional aesthetic beyond the building itself? I mean, frankly, in terms of the intent of the traditional Main Street, I mean, like, I just find, and the official plan, I just find that in terms of your setback and your requirement to promote this particular brand of vehicle, that you will require this additional space to do that? I mean, what other purpose will that so-called event space be needed for?
So that space has a number of components, and through you, Mr. Chair, part of what informed this is that, as I mentioned, the existing context along the south side of Montreal Road sees an average setback of about 14 meters. And because of the existing hydro poles, you're going to see 5-meter setbacks as well. Post road widening, our position will be about 5 to 6 meters. So we will be quite in line with what will eventually down the road exist once these properties are transformed and pushed closer to the street. So we'll be, about only 1 meter off. There is going to be, in addition to the space being used for events and active components, there is the public gateway component that's a requirement from the secondary plan, as well as the inclusion of public art. And that additional space does provide flexibility for that component as well, because it requires a gateway. And then on another matter, there was also partly what informed the position of the building was also the grading challenges on site. So there was a number of components that really filtered into where the building location ended up being. And it also happens to align well with the context. And if we were at 0 meters, we would likely have, complications with the existing hydro poles. And it would also represent a very severe deviation from the existing setbacks that exist along Montreal Road.
You're creating a new site plan for the site. In terms of the difficult grading issues, we've dealt with issues like this before. Seeing as you're revising the entire site, could not those grading issues have been resolved? There are ways to deal with grading issues, of course, and it's not that complex, certainly.
Through you, Mr. Chair, while I am not a civil engineer, we have been through this with staff on a number of issues, and it's not so much the grading issues. We do have retaining wall being proposed as well to help address those grading issues, but a lot of it is with regards to the accesses to the streets, along with as the city takes the road widenings, it changes the slope where the access is, and then that sort of has a domino effect on the rest of the site. We do have the proposed elevation of the building. We're basically trying to design it so that the visual, the transparent windows is really right at street level. As you're a pedestrian, you walk by, it's the showroom component will basically translate from the design right to the street with what we're proposing.
Thank you, Mr. Chair. If the other committee members agree, I'd like to reserve on this application. Thank you.
Ms. McLean.
Thank you, Mr. Chair. I just had a question on the retention of the repair shop. And when we sever the lot, whether that repair shop is a permitted standalone use on that newly created parcel. So I'm not sure if that's to planning or to the to Ms. McQuaig.
Well, why don't we get both opinions just to be safe? Ms. McQuaig first.
Through you, Mr. Chair, the existing repair shop has it's currently compliant, and the alteration of the lots will not remove that compliance.
So it would be a permitted standalone use on that lot, newly created lot, under the bylaw, correct, without the dealership building.
If the dealership building weren't constructed, it would still be considered compliant, yes.
Okay, thank you.
And Mr. Hamilton, do you have any opinion on that, please?
Through you, Mr. Chair, that is correct. A service and repair shop is a permitted use in the zone.
Thank you. Anything else, Ms. McLean?
No, I think I guess the concern of the neighbors regarding the landscape along the southerly boundaries, I think what we've heard is that will remain, or it will comply with the bylaw, and it's just the newly created interior lot line that requires the landscape reduction. Am I correct in that?
Through you, Mr. Chair, Ms. McLean, that is correct. We are not looking to reduce any landscape buffer that would be required abutting the residential areas. Our variance was modified and reworded to only apply to that interior lot line being created between the proposed Porsche dealership and the existing Audi dealership.
Thank you.
Ms. O'Sharon.
Thank you. My question is about the front yard setback and the kind of the gateway feature that's being created. If we were to adjourn this and wait till longer in the site plan process, would you have more details available about exactly what that will look like?
We have actually, at this point, I would say we're about 85 to 90% of the way through site plan control. As Mr. Hamilton had indicated, we're on round 3. We have already been to the urban design review panel, both informal and formal, and have updated our plans based on their design recommendations. So they are currently comfortable with the gateway as proposed. We have addressed their comments through our most recent submission, and it's being reviewed with staff. It's my expectation that the next set of comments we receive from staff will be relatively minor and easily addressed. And my expectation is that we could look at receiving a delegated authority report towards the end of July.
Is it feasible for you to put whatever slide might be appropriate from your presentation up, just so we can have a closer look at what's being proposed in that specific location?
Yes, if you want to open up the coordinator can pull up the application. Perhaps slide 9 or slide 7 would be, slide 7 is an older render. Slide 9 is the most currently up to date. So this, yes, that was an older render. So slide 9 in front of you is the most up to date site plan. And it does show the gateway at the corner has low landscaped planters, bench seating. There will be some form of public art somewhere either in the public gateway or along the frontage. That is yet to be determined, and to my knowledge will be a condition of site plan control. But public art was a requirement as part of the secondary plan as well, as was the gateway.
Okay, thank you. And what would that look like if we were to vote against the request for the front yard setback and you had only 2 meters to work with? Have you created options or?
When we pre-consulted with staff and have been through these discussions, it was predicated on being able to achieve a certain design and achieve a certain consistency with regards to what's existing along Montreal Road and what will be existing along Montreal Road. And we felt this design was a very balanced approach and still provides that active space. It also incorporates it will be a specific area for outdoor events and provide that active frontage to the street over and above what currently exists today, and opens up the site, which currently, and I think some of the comments provided speak to the fact that it is very tight with the building currently, and this allows us room to provide that public gateway. And if we don't have that front yard setback, it really limits us in what we can do with the gateway and also where we can put future public art.
Okay, thank you.
Thank you.
Thank you. You've seen, Ms. McQuaig, that there are 2 conditions, existing building to be demolished and existing building on site plan 1 to comply with limited distance requirements of the OBC. Do you have any concerns with those?
No, I do not.
Okay. I believe we do have a few speakers. The committee coordinator can confirm. I believe we have at least 1.
Yes, Mr. Chair, we have Ms. Whittle on the call.
Okay, thank you. Ms. Whittle, please.
Apologies. Thank you, Mr. Chair. Shannon Whittle, 128 College Circle, Ottawa.
Thank you. You have some concerns?
I did. Ms. McQuaig has explained a lot of them away, which is great. I think my concerns could have been avoided if I had known about the plans. I must have missed the posting of a notice or any other kind of consultation. And I think, you know, it's really important to consult with direct neighbors when planning such a expansive change in a neighborhood. But that being said, my only other thoughts after seeing Ms. McQuaig speak is the building that's going to be new, that's replacing the existing Maserati dealership, is going to take up the parking garage, I think is what it is. The new building near the corner of Montreal Road and St. Laurent. So that is quite a large footprint. And so my concern now, looking at your slides, is just that any activity, so I'm pointing here because this is where the lot is in relation to my house. Any activities on the part of the workers, the vehicles, maintenance, things that happen on that existing space is probably now going to be pushed back closer towards the property, the residential properties of which I am part of. This just occurred to me as I was looking at your slides. So I don't know if that's relevant to this, but it's a concern that I have after seeing that. Then I'll just quickly state my other concerns that were partially addressed. The repair shop, I understand, is now not going to be demolished. So that's right on the property line where St. Laurent Boulevard is. And there's a bus stop right on the other side of that wrought iron fence. And currently there's like weeds and shrubs kind of growing out from the Mark Motors property out into the little bench area where the bus stop is. It just doesn't seem like anybody cares to maintain it, you know, landscape it or make it in any way attractive. But I understand that that's not going to change. So you're not demolishing that building. And so I don't think my concerns are relevant with that. The bus stop on Montreal Road, it looked like from your plan, there's going to be a lot of space for people waiting for the bus now, especially with this increased front yard setback. So really my only concern now is just the sort of movement of activity that was over there in that space and is now going to probably be pushed back towards the southwest sort of corner of the innermost lot where my house is. Because I already hear a lot of activity, and I just, you know, and then there's also a huge snow pile in the winter, huge, massive. And I'm assuming like the grading is still going to keep the water from that going back towards the lot and down into the storm sewers. I don't want to ramble, but
so a lot of what you're mentioning, Ms. Whittle, is matters that will be addressed in the site plan process. The city's engineers will be looking at things like runoff and where the snow is going. These will be things that will be engineered and should be addressed. And you can certainly reach out to the planner who's responsible for that file to have a discussion about that. It's not something that we get into here, but it will be looked at. It is the type of thing that is definitely looked at by the city. So I think that if you wish, you could reach out to the planner who's managing that file about those issues. But you did raise a point about sort of the noise and any buffer along Moraine Street, I guess. Ms. McQuaig, your site plan showed a green strip along sort of in an L shape. Is there anything to be, what is going to be there?
Through you, Mr. Chair, the city staff have requested that we retain the existing cedar hedge for that buffer. They have also requested that the fence be made opaque, which is going to be, we've already provided that resubmission that we will be making the fence opaque. So This, in terms of what the city has requested for site plan control, the existing buffer is to remain, and the rear yard setback we exceed quite notably at this location as well. And just as a point to Ms. Whittle, the repair shop is proposed to be recladded, and I expect with that alteration, the existing landscaping will be cleaned up and tidied up at that location as well.
Thank you. You mentioned the fence. Is the fence following that L shape along Moray? Is that what you mean?
The fence, I can't recall off the top of my head if it carries right up to the 616 Saint Laurent repair shop, but it does extend all the way across Moray, and I believe down south as you get into that corner as well. And so that existing fence, which I believe is, the city was looking for, I believe, a 6 meter opaque fence, and I believe it's currently 8 meters, and we are proposing to make it opaque. I don't recall exactly what method the architect was proposing to use, but we will be making it opaque in accordance with what the city has requested.
You mean feet, right? Not meters?
Yes.
Okay, thank
Yes.
you, because that would be a very large fence.
Apologies for that. That would be a huge fence.
Okay, thank you. Ms. Whittle, do you have any other things you want to cover? Okay, thank you. Mr. Wilder?
Thank you. Ms. McQuaig, so we're going through 3 iterations now of the site plan. Do you have the latest you can put up for us? I'd like to have a look again at the gateway corner that your your firm is going to be providing. Is there an enlargement of that corner in terms of the landscaping, the bench, supposed bench, the planter box, whatever that you're going to be providing?
If you can move to slide 7. I don't have a zoomed in. This is an older render, but the gateway in terms of the, thank you. The proposed paver design, the display, as well as the low landscaped planters, was all in terms of our discussions with UDRP, moving through from informal to formal. Some slight modifications have taken place, but overall, this is the design that has resulted from our UDRP discussions. There was only one component of the UDRP design discussion. They had wanted the proposed display vehicles to be elevated. There's some logistical issues with that, and just with regards to the openness of the corner from the transportation department's perspective, they wanted to maintain that visibility. So the proposed display will be as it's presented.
I see.
Sorry, just to add one more comment, Mr. Chair. It is proposed that public art will be proposed somewhere along either the public gateway or along the Montreal road frontage. That has yet to be determined and is going to be a condition of site plan approval.
So basically what we have there is by moving back, as you're saying, going back to the 8.93 meters, what you've created there almost is in my mind, a plaza, a showroom plaza exhibiting the luxury cars at a very busy intersection there. I mean, there'll be a piece of art put down there, but I guess that's the extent of it. What you've got is a huge open plaza where I guess there'll be events promoting your vehicles on special days, obviously, when you'll have more vehicles out, perhaps every so often. But I mean, yes, I appreciate what you're doing there with the corner, but nonetheless, it's certainly still not in compliance with the zoning bylaw. Anyway, that's just my own comment. Thank you.
I believe there are no other speakers. Members of the committee, is this a matter we prefer to reserve on? Ms. McQuaig?
Mr. Chair, if I can just leave with one final comment, I do want to reiterate that the zoning bylaw It proposes a maximum setback of 2 meters or 5 meters where hydro exists. Hydro does exist along this corridor, and there will be setbacks of 5 meters when these other properties are developed from their current context of an average of 14-meter setbacks. Our post-road widening, our building will be positioned about 5 to 6 meters from that eventual line post-road widening. So in effect, we're only looking at a 1 meter difference at most between what will exist on Montreal Road in terms of a setback from what we are seeking. Thank you.
So members of the committee, if you agree, I suggest we deal with this as a reserve matter. Thank you. Thank you for your presentation. You'll have our decision within 10 days.
Thank you.
Okay, moving along to item 10, 144 Mulva Hill. Mr. Mason, I believe, is the agent for the applicant.
Yes, hello.
Hello, Mr. Mason. Do you have video?
I'm working on it. There we go.
Okay, so for the record, your name and address, please.
My name is Andrew Mason. I work for Crossford Construction here at 76 Holland Avenue.
Thank you. So the committee has reviewed your requests. We're fairly aware of what you're looking for.
Sorry to interrupt, Mr. Chair. Can we get a stat
yeah.
deck on this one?
No, not me. Sorry, Mr. Mason. Do you solemnly swear or affirm that the notice provided by the committee was posted on the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time?
I do confirm.
Thank you. So on this application, does any member of the committee wish to ask any specific questions? If you could just very briefly, Mr. Mason, talk about the two reliefs requested.
Absolutely. So the subject property is a corner lot in the area in that location. The current house itself is located within the corners yard setback that was applied after, of course, the house was built, as many of the houses in this area are. So the setback is halfway through the property itself. The clients are looking to expand and by putting a second floor on the top of their home and an addition onto the back of the home to accommodate their growing family. The rest of so what we're asking for is a reduced side yard setback to allow the current side yard of their house, so the current existing wall of their home. Which just allows them to be able to build on top of their existing home. I believe, sorry, I've just lost my form here to find out what the other variance was.
Variance one is to reduce the corner setback to 1.93
that's right.
From what ought to be 4.5, and the front yard setback reduction of 5.45 from what ought to be 6 meters.
Yeah, so those are just the existing conditions of the home. That's where those lot lines are established by the existing home. So sorry, I kind of looped them in my head in the same spot.
Thank you. I don't believe we have any speakers for this. Members of the committee, are we okay to vote on this? Okay on approval? Thank you.
Thank you.
Okay, moving along to items 11, 12, and 13. 73, 75, 77 Paulson. And Mr. Segreto.
Mr. Segreto seemed to have left the meeting. Perhaps we can step this one down.
Sure. We will put this aside and see where where we wind up with later. So items 11, 12, and 13 are set aside and moved to the back of the agenda. And we will move to item 14. Oh, I'm sorry, 14. In a second here. 14, there was a request for adjournment. So we are to item 15. 6935 Notre Dame Street. And Sam Hanna, Masood Sam Hanna, are you available?
Sorry.
State your name, please, and your address.
Masood Hanna, it's my son Maxim Hanna. We're seeking consent of the committee to sever a property that we own at 6935 Notre Dame.
Okay. And you see here you have 3 severances, each resulting from 10-meter frontages, all 55 depth, and all area of 55 square meters.
That's right.
And the conditions that have been proposed, there's no concerns from planning provided. 5 conditions are imposed. Cash in lieu, tree planting plan, and I'll come back to that in a moment. Independent services, noise attenuation study or provisions to add AC and warning on title, and a grading and drainage plan. Are you aware of these conditions?
Yes, we are. For these conditions, basically, we're waiting for your decision on the severance. We're not aware like what all the conditions are.
Okay, well, those are the conditions. And those, I assume you've been provided with. A question for Ms. Young. Ms. Young, is there any form of security or financial provision that will be assisting in accomplishing what the tree planting plan is setting out to accomplish? Or in this case, is that not applicable?
Not for this one. In this case, no trees are being removed. So the tree planting plan is requested as something that's good to do to benefit the streetscape.
Yes.
But I didn't think it was necessary to put in securities.
Okay, and what is the tree planting plan in a nutshell?
Well,
what's the strategy? From Ms. Young, please. Ms. Young, how many are we, 1 tree per lot or what?
Yes, that is what I'm proposing, is 1 tree per lot in the frontage if possible, but I need to see the plan to know if that's possible.
Okay, and you would not be collecting securities now under this scenario?
No.
Okay. All right, Ms. McLean, you have a comment or question?
So just to follow up on the condition, if the applicants just sell the 3 lots to a new purchaser, how does this tree planting plan get implemented at this stage?
well, we're planning. It's that.
Sorry, that's to the forestry staff. Sorry.
Thank you. Through you, Mr. Chair. I guess there is no guarantee that it would happen. I would hope that the plan would be transferred to the new owners. I don't know if you have an opinion, if it's better to do that through a development agreement. I didn't want to add cost to this. So yeah, we can change that if necessary, but there is some risk that it won't happen. But in that case, the city can still plant these trees as well through the Trees and Trust programs. The future owners can even apply to the city to have them planted. I just would like to see the plan in place to show that there is a plan to get trees in the ground and to make sure that space is left in the front in order to plant trees.
But just
Okay.
if the applicant submits a tree planting plan, it's not enforceable on the new purchaser. The new purchaser may not even be aware of a tree planting plan. So I see this condition more of an information type comment, but I don't see it necessarily going anywhere. That's the confusion. I just don't understand how it's going to result in any new trees. And I'll just leave it at that sort of thing.
So I think we have, that's the comment that we've been sort of hitting on today. And certainly from what we've been advised is that panel 2 is just beefing that condition up a little bit so that it becomes something that's enforceable or operational, and also so that a purchaser would be more aware when they purchase. So that would be by way of a development agreement. I personally prefer that approach. Not sure about the rest of the committee, but that would be my preference. Does committee have any comments on that?
Well, I just don't think that forestry staff are really looking for an enforceable condition. That's what I sort of wanted to get out on the record. So if the applicants are going to sell these 3 new lots to different purchasers, just wondering how trees get planted, or I guess there's no mechanism. And I guess that's what I'm struggling with at this point.
So the other 2 committee members, your thoughts on this, please?
No, Michael, I think your suggestion, I understand where Heather's going from. I think your suggestion is where that's what I would pursue. Actually, I would support what you had suggested.
Ms. Oakeshott?
I like what you're suggesting, Mr. Chair. On the other hand, I don't know if we have, sorry, there's construction going on nearby here. I don't know if it's a matter for the committee to delve into as to whether the lots will be sold and what will be done with those lots. And we don't have that in front of us. So I don't know.
I see this as similar to actually condition 4, which could require the addition of noise warning clauses on title, or even the provision of an AC unit, which would be, carry forward onto the next purchaser if the lot is not constructed. I don't see a huge difference with that. I guess for me, I would rather see either no tree planting plan, which I actually don't favor, or a tree planting plan with some mechanism to have it happen. But I'm in the hands of the rest of committee in terms of what they wish to do. So I'm going to put you on the spot. I think I know where the other 2 are. I put you on the spot, Ms. Sharon, on what your where you would have.
I'm sorry, I'm actually going to have to ask you to repeat that. The noise was so loud here, I couldn't hear the comments.
So given the choice of implementing a development agreement or not, what is your preference?
My preference would be not to go ahead with that at this time.
Okay, so that's 2 and 2, so that will not happen. So we have the balance of the other 4 conditions. There are no speakers on this. Members of the committee, are we able to vote on this now? On approval? Thank you and good luck with your project.
Thank you, sir. Thank you.
Okay, items 16 and 17, 1441, 1443 Queensdale. And I believe we have Kiana Simmons and/or Kayla Blakely. Hello, please state your name and your address for the record.
Good afternoon, Mr. Chair. My name is Kayla Blakely. I'm a planner with Novatech, 240 Michael Copeland Drive.
Thank you. And will you be responding to questions then today?
Yes, Mr. Chair, I'm available to respond to any questions or provide an overview. If you'd like, I will pass to my colleague Kiana to do the oath.
Okay, that's where I was heading with this. So Miss Simmons, your address for the record, please.
My address is also 240 Michael Copeland Drive.
Thank you. So we'll administer the oath. Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time?
I do, yes.
Thank you. So there's a number of conditions here, as you've seen. We have reviewed the application fairly thoroughly. We're quite familiar with the area as well. Members of the committee wish to ask any specific questions? Ms. McLean?
Thank you, Mr. Chair. I wonder if I could have the agent's opinion on the 2 tree conditions, I guess, that are being requested and how they will be met when the new dwellings are built, or how that will be enforced.
Yes, of course. Through you, Mr. Chair. The arborist for this project has had an opportunity to review Ms. Young's comments and has addressed them. They've agreed to work with the civil consultant to ensure that the servicing design will avoid any conflict with the tree that's within the current front yard. So it's now intended to retain that tree. Therefore, there's only one proposed tree to be removed where it conflicts with excavation. So the owners are proposing 3 new replacement trees per the city's standards to offset the compensation that they would otherwise seek. I understand that the revised report has been submitted to the city staff, and we have no concerns with the conditions, given that I believe they've been resolved.
Ms. Young, any comments on the trees?
So can I so the first tree condition requires that any proposed structures will have to be to the satisfaction of planning. And so we're not dealing with any construction per se in these applications. And I guess the third condition is to submit the tree planting plan. And I'm just trying to understand how this works out, because if you're going to sever these properties and sell them, how this will be enforced how the city will enforce these on the new owners. So again, the third condition includes a phrase that says this plan will include permission from owners where planning is proposed outside of the subject property. And I guess I'll address this to Ms. Young as well, but what does that mean, that other owners have to become involved? Or I just want to get some clarification.
Okay, through you, Mr. Chair. That sentence was because I believe there is one adjacent tree being removed on this site. And so I was thinking, and in other cases where adjacent trees are impacted, sometimes it would be beneficial to look at planting on those adjacent sites. So I'm basically just using that sentence to say we're open to the landscape plan, including other nearby sites, as long as they have permission from the owners to plant on other properties, and as long as they show those properties on the plan, the landscape plan. Does that answer your question?
So to the applicant, does that propose a problem if an owner of another property isn't willing to give the permission? Does that not allow you then to sever the property? I'm just not sure. Yeah, I just want to be sure that we know how this is going to occur.
Yes.
I don't know if, okay, go ahead.
I was going to comment, I believe it is the intent to retain all trees on adjacent properties, it was only a single private tree to be removed. So right now the owner's contemplating the replacement trees on its own property. Otherwise, I believe it is typical practice to consult with your neighbors to get their permission to remove any trees. So I guess if that was the case, they'd discuss replacement trees at that time. But I don't believe that's applicable in this case.
Okay, thank you. I just think that these conditions need to be further clarified in the case where an applicant is applying to sever and they may not be developing the proper property per se. So I'm just going to leave it at that sort of thing. Thank you.
Any other members of the committee have any questions? I have a question for the planner, Mr. Hamilton. The Airport Authority has requested a condition on title, yet it does not appear as a condition listed. Can you let me know why that is?
Sorry, that may be my mistake. I was not aware. So I did not add one in from the Airport Authority.
But as far as you know, they have concerns and they want a condition like this?
No, I was not, sorry.
So where does that come from? That's we've got that listed as a condition here, as a concern here. The senior level of government saying that they would like a condition applied.
Sorry, are you asking where the condition gets applied or who requests the condition, like if it comes from planning staff?
It appears right now that the Airport Authority is requesting the owner to agree to have a condition put on title, but it's not a condition listed by planning. Why is that?
In my planning report, we only include the conditions provided by planning staff, so planners and engineers from the city.
It begs the question why they're even circulated, I guess, if none of their conditions are going to be applied. Certainly we do that with hydro. I'm a little perplexed on that one. Members of the committee, I'm not comfortable ignoring a senior level of government's requirement for a condition. Any feedback from members, Ms. Sharon?
I was just going to say, yes, I agree with you, Mr. Chair.
Ms. McLean?
We may want to put a condition on that the applicant satisfy the requirements for the Airport Authority and leave it at that. If the applicant's willing to leave to have the condition changed.
Yes, thank you. Mr. Wilder, you disappeared on my screen. Where'd you go?
No, I agree. I agree with the putting in that condition with regards to the Airport Authority that they comply with the Airport Authority's comments. So,
thank you. I believe there may be another speaker. Is that correct, committee coordinator?
We do have one participant on the phone. I do not see them online though. So no, I would say we have no more registered speakers.
Okay. For the agent, if I guess you have two options. One is that you agree to put the notice on title as listed by the Airport Authority, or agree to satisfy the requirements of the Airport Authority. What's your preference?
We would have no issue with the condition being in the decision, given that it's just the notice on title in this case.
Thank you. Ms. McLean?
Thank you. I just see the gentleman that wrote in on this. I do see him listed in the participants, Mr. Nugent or Mr. Hine. I do see him down.
He is there. Mr. Hien, do you wish to speak?
No, not at the moment.
Okay, thank you. Thank you, Ms. McLean. So on the application as amended with the condition for a notice on title satisfying the requirements of the airport authority, members of the committee, is this approved? Thank you.
Thank you very much.
All right, so here we are on 19. Item 19, 114 Stanley Avenue. And we have Mario Poulin.
Hello, Mr. Chair, members of the committee. My name is Mario Poulin. I'm with Cloud9 Drafting and Design, and the address is 544 Neighborhood Way.
Thank you. I'll be administering the oath. Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible at that time?
I swear.
Thank you. So I think this one's been around before, and I think what we're talking about is some changes to the relief sought under C, D, and E. Perhaps if you could walk us through those three amendments.
Sure, yeah. So the garage itself right now is encroaching on all three of those property lines. So what we had proposed originally was to pull it back on our side in order to satisfy what we had gotten from communications from Heritage and move closer to compliance. When we were at the hearing 2 weeks ago, there was some concern on the side yard setbacks, which is C and D, to try to, because it's considered to be a new building, to try to meet the side yard setbacks of the accessory structure with the walls and having just the overhang be past that rather than have the walls be past that, which is what we were applying the first time around. So we have been in communication with Heritage and gone back and forth on this again. They are in accordance with what is being proposed, which is shrinking the garage again to meet. So the side yards setbacks on both sides would be met by the wall and only the overhang would be impeding. And instead of being at 0 or encroaching, the overhangs are now at 0.3 meters from the side yard property.
So we have C and D amended from 0 to 0.3.
Correct.
And on E, we have a change to 47.95. Is that correct?
Yeah, because the side yards came in, the massing also came down. Correct.
Okay. I believe there was a request, although I'm not sure because I don't believe I was at that meeting, but there was a request by a member of the committee if you had any photos of what was going on there. I think Ms. Oak-Charon, you had mentioned that.
So I did submit some, so there are pictures in the slides that were submitted, particularly from the rear lane. And there were some 3Ds that were also redone for Heritage that I submitted on Monday. So yeah, so that's from the rear. So you can see that on the left-hand side where the red roof is, there's a garage that's very similar in scaling and massing and size. That one is even with where ours is. We are asking for the rear yard variance to push ours a little bit further back just to increase accessibility off that lane. I know that was a comment coming in from one of the neighbors, which was also a comment coming in from the client to try to minimize or maximize the efficiency of that entrance. But you can see that on the left-hand side, it is very tight and from roof to roof. And on the right-hand side, the garage is actually a foot, the wall of the garage is actually a foot and a bit over the actual property line.
Thank you. Members of the committee, do you have any questions? And there are no other speakers. Therefore, as amended for C, D, and E, are we able to approve this now? Thank you. We're approved.
Perfect. Thank you very much, Mr. Chair, members of the committee. Have a good day.
Thank you. All right. So now we are moving to other business. I realize we set aside another one earlier, but we moved that. I think we'll put that behind this one. So we will move to the other business item, which is 304 Lanark Avenue. And there are a few speakers, including the agent and also a few others. So I think what we're going to do is, I'm not sure, I think Mr. Chown will be doing the speaking. Is that correct?
Yes, Mr. Chair, I will speak to this request to remove a condition of consent.
Okay, and could you maybe, as you do that, Mr. Chown, address the notion of change versus removing and whether there is a difference and how that difference might be considered?
So I'll deal with that first, Mr. Chairman. I think removal is a change. So I don't think there's a differentiation between removal and change. This condition, well, as it's worded, let me just go to it. The owner provide evidence that the accompanying minor variance applications have been approved with all levels of appeal exhausted. So we're going to request that you change that condition by removing it because it simply is no longer relevant to the decisions that were rendered by the committee in April.
Okay. So there is a little bit of concern around the committee table, not being lawyers, that remove and change may or may not be the same thing. And that one way of dealing with that is to actually amend or change by saying that you're required to provide evidence that you meet the zoning bylaw requirements. And that might be.
And Mr. Chair, I think that would be a brilliant solution to the question you've put to us. If the condition was to be changed to provide evidence that the consents conform to the zoning and that's in full force and effect, that would be perfect.
All right. So that may be something we discuss. Ms. McLean, did you want to pursue anything with Mr. Chown at this point?
I'm just going to check my notes here. I think that was, I was wondering about the change versus removal. And I think that was the only question that I had on it. Thank you.
Thank you. Any other members of committee, do they have any questions or comments? No. Okay, thank you. So we're going to open it up to speakers. If the speakers, please, would confine your comments to the change issue that's before the committee today. Is Mr. Poulter present? I do see Mr. Poulter listed as a participant. Are you there, Mr. Poulter? Okay, I'm going to move to the next one. Ms. Ganji.
All right, Karen Gange, 310 Lanark Avenue. My understanding is that the only result of this change request, however you want to put it, by the builder, would be to essentially vacate my appeal that I've sent to LPAT. It doesn't seem to me that there's any other purpose for the committee to even consider this. And that seems to be the only result from this. In addition, during this process, and I have a copy of an email from Nancy Young, Nancy Young, stating that, and I'll use her words, we've obtained legal advice that the bylaw that was in effect at the time of application is the bylaw that must be used to evaluate the submission. So when I read that, when I look at other bylaws, that tells me that the builder is subject to the requirements that were there when the application was put forward. The application needed to have a variance, and that's the process. To allow this to happen would be allowing a developer to cherry pick. I like this bylaw that's in effect now. I like this one that was in effect when I made my application, and completely disregards the processes that are in place, specifically my right to file the objection and have some discussions with LPAT. In addition, I would like to say that if the builder and the owners of 304 Lanark had made any sort of attempt to talk to the neighbors, particularly the adjoining neighbors, before they started down this road, we could have had some very good and profitable discussions, address some concerns, and you'd probably be halfway built by now. However, the builder in 304 made no attempt to talk to me or to the other adjacent neighbor, Steve Katz, and his family. So it's a summary. It's like the bylaws in effect when the application was submitted are the ones that apply to him. He complied with that. He puts in the variance request. He gets a variance request. It has conditions. Those conditions need to be met. He should not be allowed to, again, cherry pick and decide that now it's better. So I would rather have these bylaws with my old application. And I think the process that's in place should be followed and honored by the committee. Thank you.
Thank you. Mr. Poulter, I see that you're now there on the question of the change requested by the proponent. Do you have any comments that you'd like to convey to the committee? Mr. Poulter, your microphone is muted.
Do you hear me now?
I can, sir.
Okay, thank you. Yes, I'd like to speak about the process in that if we look at the judgment of the committee, the manager of planning, I think it was for the city, was tasked with imposing suitable conditions, but city policy is not to impose anything on the developer beyond the bylaw requirements. In short, the arbiter, the Committee of Adjustment, has appointed another arbiter to look into details such as flooding via both on-surface and subsurface such as through the sanitary sewer. The secondary arbiter being appointed by the committee is a bias and not capable of fair judgment because of their policy of not to impose anything on the developer beyond the bylaw requirements. So I've spoken to the person that the manager of planning has appointed to talk to me, and he told me that no, we're not going to impose anything. So the fairness of the committee in terms of delegating authority to get into these engineering details is really not there. I also spoke to Steve Kaz this afternoon after the meeting began at 1 o'clock, and he has to make a living, and he cannot appear today. He wants to appear if, depending upon, or he wants to appear, but he can't. If the hearing was later, perhaps he might. We want to point out that he is prevented under the old bylaw from the old tree bylaw from making having appropriate protection for his tree, and now under the new bylaw, well, he doesn't get to it. So again, what is happening is it's sort of cherry picking in conditions. Either we should set or run with a set of rules when the hearing was requested by the applicant, that is back in December, and live by those rules, or live by the rules that are today. But to say, oh, let's live by cherry-picked rules that are most applicable or most advantageous today to the applicant, it's really unfair to those of us who would like to bring forth our concerns. Specifically for the trees, I note that the applicant has, in the case of the trees of Steve Katz, the applicant has excavated right beside that tree. I witnessed the applicant's developers actually there with a saw, sawing back and forth, cutting out those roots of Steve Katz's tree. And then to date, since the excavation, the applicant has done nothing to protect that tree in terms of giving it water or structural support. What has happened is they've excavated right beside the tree so that the root mass doesn't have the mass of earth to protect it.
Sir, if I could interrupt for a second.
Certainly.
The question the committee is being asked to decide upon is whether it is appropriate to change the condition as presented by the proponent. What is your opinion on that?
No, because we need to live under one set of rules, not under cherry-picked rules. If the applicant would like the new rules, then let's restart the hearing with the tree rules that exist at this time, and we can run forward with that. Steve Katz was unable to have due process that is provided for in the bylaw, in the new tree bylaw. So
thank you, Mr. Poulter. Your 5 minutes are up. If you could just wrap up, please.
Okay, so my concern is that if we're going to open things up to have the applicant being able to say, oh, things have changed, let's run with what's changed. Well, then let's run with everything that's changed. And let's also give the committee of adjustment the ability to correct its judgment with respect to imposing an arbitrator, a third-party arbitrator, and replace the prejudicial biased arbitrator of the manager of planning with somebody who really has the ability to arbitrate fairly, as opposed to required to follow a biased policy that the city has.
Thank you.
Thank you.
Okay, so Mr. Katz, I understand, is not here. And committee coordinator, can you just confirm he is not on the list?
That's correct, Mr. Chair. He's not on our attendees list.
Okay, thank you. Members of the committee, do you have any comments or questions? Ms. McLean?
If I could just clarify, Mr. Chowan, on the request to change the condition, is it leaving the condition as it is, but adding a sentence that say, alternatively, the applicant provide evidence that the proposed separate lots meet the zoning bylaw requirements? Or are you suggesting that we remove the condition entirely and replace it just with the wording that provide evidence that the new lots meet the zoning bylaw?
Through the chair, thank you for that question. I think it's worthwhile for us to just back up and understand what the purpose of condition number 1 is. And the purpose of condition 1 is to ensure that the lots that are being created conform to the zoning bylaw. The committee has an obligation to make sure when they're approving a consent application that the lots being created conform to the zoning bylaw, whether or not it needs a minor variance. At the time that these applications were filed, which was in December of last year, we did need relief from the zoning bylaw. Today, we do not. So we are not, I want to be clear, we aren't cherry picking. We don't have control over what zoning bylaw applies to this application. We have no control whatsoever. In the case of the tree bylaw, which is passed under the Municipal Act, Ms. Young provided an opinion that the bylaw in force at the time of the application was the bylaw that the city was going to rely upon. Bylaws passed under the Planning Act are different. And so that, for instance, when we go in for a building permit application, the permit has to conform to the zoning bylaw on the day that the permit is issued, not on the day the application is filed. And we're in a similar situation here where the lots need to conform to the bylaw on the date that the lots are created. And as of April of this year, these lots fully conform to the zoning bylaw as amended. There's no transition clause that said the old provisions continued to apply to this application. So we now have 2 lots approved by the committee, the consent's approved, they fully conform to the zoning bylaw today. So to answer your question, Ms. McLean, I think it would be cleaner and direct in terms of the purpose of the condition to simply say that the owner provide evidence that the consents conform to the zoning provisions that are full force and effect. And if that required a minor variance, then we'd have to show you we've got a minor variance. But we don't need a minor variance because the bylaw that we varied doesn't even exist today. It's gone. And so we can't vary it even if we wanted to. So the variance has no status. It's meaningless because that provision of the zoning bylaw that it varied doesn't exist today, and it won't exist on the day that we finalize the consent. What does exist today is an amended provision that was approved by council in April and was not appealed. So I would like to keep it simple. I'm just suggesting that. We can do it either way. I'm in the hands of the committee, but I would like to keep it simple if we could.
Okay, thank you.
Any other members of committee have any questions or comments?
I have a question if no one else does.
What's the question?
Well, my question is, since there's no impact from this new bylaw to the developer, builder, etc., why are they asking for this? It seems to me the only reason that they're asking for this is to eliminate my appeal, which is in accordance with the processes set out by the city and other areas. I failed to see if this is such a trivial thing as Mr. Chow was saying now, but there's no reason to change the prior decision.
With respect, Mr. Chairman, we can't clear the condition the way it's written.
I was going to say that, Mr. Chan. Okay, thank you. Members of the committee, I'm going to suggest that this matter be held in reserve and we'll discuss it later. And we will have a decision in 10 days.
Okay, one last question. I assume I assume that if it's not the decision that says that things should stay as they are, that I do have the ability to file a grievance or whatever appeal of that decision as well.
That's not something that the committee provides advice on, but there is a way to go ahead and get that advice to the province.
Okay, thank you.
Committee coordinator, we set aside number, I believe it was 11, 12, and 13 because Mr. Segreto was not present. Is he present now?
Yes, Mr. Segreto is online now, Mr. Chair.
All right, let me find it. It's buried in my papers here. Where did I tuck that away now? Oh, there it is. All right, so Mr. Segreto.
Good afternoon.
Your name and your address, please.
Michael Segreto, 30 Concourse Gate, Unit 47, Ottawa.
Thank you. And I don't believe there is a, give me a sec. No, so I'll have to get administer the oath.
Yep.
So do you solemnly swear or affirm that the notice provided by the committee was posted at the property which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time?
I swear it was posted.
Great, thank you. So, give me 1 second, Mr. Segreto.
Problem.
So we don't have any other speakers. And we have 3 conditions that have been, we have 4 listed conditions, but actually there's 6. And I'm just going to read them out to you for now, and then we'll get into some details about the file. So the cash in lieu, the tree planting plan, again, Miss McLean's favorite one, the independent services can convey to same purchaser condition, Hydro Ottawa easement for 73 Polson, and relocation of overhead supply to 73 Polson. You're aware of those, Mr. Segreto?
I am, and I'm okay with those. Yes.
Good, thank you. Members of the committee, do you have any specific questions for Mr. Segreto? Mr. Wilder?
Thank you. I would just like to ask the planner, I see that in just the past 48 hours, we received a revised planning comment from him, an additional paragraph, and I just want to go over this. It says the tree information report shows 7 trees on site, 4 to be removed due to conflicts with the proposed building footprints. Pre-consult stage, it was determined that the maple was in poor condition, be replaced. Fine, changes were then made, I guess, by the applicant to the rear porch width and excavation area to allow for adequate protection of the 5th and 6th tree identified. And it says the compensation of 8 new trees as per the planting plan and the value of the city trees will be required. These 8 new trees, where are they being planted? If they are going to in fact be planted, or is it going to be through compensation? Maybe Nancy Young or Ms. Wakula can explain that paragraph.
Through you, Mr. Chair, I can speak to that. So they did supply a tree planting plan, and it showed the replacement of 2 trees. So one for each lot. And so my comment back is that they could look at planting more trees, and that's the reason for asking for a revised tree planting plan. This is the one I thought I was speaking to before, where I thought they could look at adjoining properties, because the adjoining properties are kind of sharing area, I guess, through this application. So this is where it would be a good example that they could plant on other sites if they have permission. So they have a planting plan, and I am concerned that it's not really showing enough trees, but in the end, it is up to the applicant if they choose to only plant 2 trees and then pay the rest to forestry. And that is all done at the building permit stage. It's not something that we deal with at this stage. I'm just trying to get a plan to understand kind of what the balance of the tree planting would be, given that we are losing 4 trees here.
Mr. Segreto, what is your client's position? I mean, obviously, we're creating a new lot here. In terms of any new plantings on that lot when that lot is to be built on?
Well, Mr. Wilder, one of the neighbors obviously is going to be the son who is selling a portion of this property to the father, who's going to be retiring in this bungalow. I think he could probably work out some sort of agreement with his son to give him a couple of trees. And I believe that Mr. Delio D'Angelo, who's the new owner, or hopefully the new owner of this parcel of land, would be able to come to terms with the with his neighbor next door, which he's had good conversations with. So I would leave it up to Mr. D'Angelo to talk with his son and with the neighbor to see if they would be willing, to plant a couple of trees on either side. I don't think it's going to be an issue.
Thank you.
Yeah.
Any other questions or comments from members of the committee? On approval? Thank you, Mr. Segreto.
Thank you very much. Thank you.
I think that is it. Did we get everything, committee coordinator? Did we catch up to all the ones that were behind us?
Yeah, Mr. Chair, that's all of them.
Good, thank you. All right, this meeting is adjourned. Thank you.